Before we get going, I'm going to make a really quick announcement, which will give some of you an opportunity to flee. So, no, the good news for the lawyers is you're going to be happy. So we were in charge of the legal breakout, and so our title is How to Protect Your Client and Your License, a Real Estate Case Study. But just to clarify, we're talking law license. For the brokers, we're not going to focus very much on how to protect your brokerage license. So we are, you're not going to hurt our feelings if you find something else that fits what you're looking for better. But that being said, you do get an hour of, oh God, this is embarrassing when everybody starts leaving. It said legal breakout on our stuff, and then when they printed up all the stuff, we started getting a bunch of questions from brokers, so.
You're staying.
Yeah, Max, you got to stay. How many lawyers do we have in the room? Lots? Okay, so you've all found the right place for the most part.
Are they practicing?
Bye, Katie. No, you're not. Bye, Holly. Sorry. I feel bad. We thought we'd rather be honest and have you all leave than sit around and you're live too, so be careful what you say. They're taping this now. Nothing's better than my Facebook stuff, Trenton. Or John Blumenthal on Twitter, if that's where you want to. No. All right, last chance. You do get an hour of ethics for your Nebraska bar, so that's good. Iowa is undecided if any of you are in Iowa, so. All right, are we good to go? All right, well, thank you. You have found How to Protect Your Client and Your Law License, a real estate case study. I am John Blumenthal. I'm a partner at the Real Estate Practice Group at Baird Home. I have fancy introductions for you guys, but I'm going to skip the fanciest part of it and just make sure I get your practice group titles right. On my immediate right is Max Burbach. Max is the chair of Coley Jessen's Real Estate, Environmental, and Natural Resources Law Practice Group, and is also a member of the firm's Banking, Financing, and Creditors' Rights Practice Group. I'm going to skip all the flowery stuff other than to say Max is great.
I like him.
And on the far right is Todd Richardson. Todd is the managing partner of Hush Blackwell's Omaha office. Todd is on the firm's partner board and is a member of the firm's Real Estate Development and Construction Strategic Business Unit. Todd also practices in real estate and development and is also really great. So we'll spare you all the stuff beyond there. You should have gotten checked in by Rachel outside. Hopefully you did. If she did not beep your code, make sure she does so that you get your hour. I have fancy sign-in sheets, but I don't think we're going to need them. So make sure that you get your credits. Just to be clear, you'll get an hour in Nebraska, which means Aaron doesn't want to stay, but you're welcome to. Now you're offended, probably. You missed the important stuff. This is the lawyer stuff, not the broker stuff. But we'll go over some broker stuff at the end, maybe. You should have all gotten a handout. If you don't have a handout, let me know. In particular, the reason I'm pointing that out, so what we're going to discuss today, we're going to do a case study that we put together for you to make it a little interactive. What we're not going to do is mirror the PowerPoint. So the PowerPoint is going to kind of give us a little roadmap that we're going to work off of, but the PowerPoint includes a lot of relevant model rules that'll pertain to what we're talking about, but I'm not going to sit and read the model rules to you because I will put you all right to sleep, and we want to try and avoid that. So if you need to know or want to know model rules, by all means follow along with the PowerPoint or maybe study up on it afterwards. But if you're saying, geez, they're not talking exactly about what's on the screen, that's by design. So with that, we will get into the story of Awesome Acres. Maybe. If I can figure out. Okay. This part we will follow along. So, everybody in here, in theory, practices in real estate or handles plenty of real estate-related matters. The scenario goes like this. One afternoon, Max gets a call or Todd gets a call from our good client, Johnny Awesome. On the sheet, it says to Jenny Lawyer, so it could be to Jenny Lawyer as well, but it'll be, yeah, that's Todd. Okay. So Todd will be Jenny Lawyer for the purposes of today. In our scenario, Jenny Lawyer works in a firm of 5 other lawyers. That's not the case here with Todd and Max, and we'll talk a little bit about their experience. Johnny wants help buying real estate that he's going to develop into awesome acres. Johnny's very excited, gets on the phone with, in this case, Todd or Max or Jenny, starts talking about his project, that he's got 3 partners, he's got a contract already signed, ready to do diligence, due diligence, everything is awesome. So let's talk real quick, Todd. Tell us, so we talked about 5 partners in the scenario, but obviously everybody's got, some may be in solo practice, some may be in bigger firms. Todd, tell us a little bit about Hush, how many lawyers you have, and let's start with a little bit about what your intake process might be at this point.
Yeah, so our firm, Hush Blackwell, has about 600 lawyers and 15 offices. And so the client intake process that we have is probably more extensive than some. But we thought we'd just kind of walk through what that looks like. So in this case, where we have somebody who makes that call, there's 5 partners potentially involved. We're going to kind of try to gather that information on the front end, make sure we understand who it is that we're representing. We'll talk more about that as we go along. But we have just kind of a client intake form that we fill out that's going to list who our client is, as well as list who the related parties are. So in this case, if we're representing the entity, we've got we list the 5 partners. Also, we find out in that process who's on who the seller is, any related parties with the seller. We kind of get as much information as we can down. We submit that into the team that we have within the firm that manages the conflicts. And what they do, they actually go through a pretty extensive process where they're taking the information we give, but they're also then checking. So in this case, they're looking at the seller entity. They're going to do D&B searches on those to see who are other related parties. We have a couple other resources too to make sure that we're picking up if there are any related entities or conflicts that are not obvious from the form, so we can identify those on the front end. As I said, for the client side, we do actually do a D&B on the front end, just not to identify just any major issues there that might exist. They'll also do Westlaw, Google, searches on all of it. So we're really trying hard on the front end to identify who are the potential parties, what conflicts do we potentially have in the matter, so we can address those on the front end and not get into the deal and then find out that, oops, we had something we weren't aware of that we had to try to resolve. No.
Yeah, no.
Actually, we have all of that's administered. We have a team that does it, the non-lawyer team really, that does that whole process. If there are conflicts and that it goes out, yeah. So we're not. Yeah, it is very good, but none of that is billed to the client.
Yeah, and actually, Trent, that is a fair question. And for the brokers who are in the room, I think most attorneys, their intake process, I think it's fair to say that most attorneys in firms or their solo practitioners aren't going to bill you for their intake process. And if they do, you should get a clear expectation, or before they do, you should ask, what am I getting billed for and what am I not? And you should never be afraid to ask your attorney that question, what am I paying for and what am I not paying for? So that really is a fair question. Can everybody hear Todd okay? Are we all?
Good. Yeah.
Okay. I had a head shake no back there, so you might want to go with, yeah. So Max, we talked a little bit, or Todd touched a little bit on their intake process, and for those of you when you go through your handout, we start with the basic premise that a conflict of one lawyer in the firm is a conflict of all lawyers in the firm. Max, what are some of the initial questions? How far into the conversation do you get with Johnny Awesome before you stop him and find out what's going on? Tell me a little bit about some of the initial questions that you're going to ask.
Yeah, similar to what, is this loud enough? Similar to what Todd was saying, it's important, and we try to find this out immediately. I usually start, because I don't hear as well, I usually start by saying, what was your name again? But then you find out who are the other players involved, because you need to know, if they have business partners, who they are, who's on the other side. If they're far enough along, they've got lenders, it's nice to know that too, so that we can run a conflict check as well, because you have to find that out, and you don't want to get too deep into the conversation and somehow start in a lawyer-client relationship and then realize afterwards when you run your conflict check that, oh wait, now we have to back out because we have a conflict. So our process is similar to Todd's. His, obviously he's a 600-plus lawyer firm and multi-offices. We're 60 lawyers. So we don't quite do as deep of due diligence. I think a firm like that, you're looking for industry relationships as well. We're looking primarily initially to identify people and companies that are involved to make sure that we don't have an issue.
So along those lines, in our case study, Johnny Awesome talked about having 3 partners. A lot of us put together real estate transactions anymore, a lot of LLC formation, some corporate formation, but right off the bat, let's say that Johnny Awesome wants to form Awesome LLC with his other 3 partners. Talk to us a little bit about whether you represent the individual. Who's your client at that point?
Yeah, especially when there's, multi-members. We always represent the entity. If it's an entity client, that's who our client is. It's less of an issue if it's a single member LLC, because then you've got an identity of interest and objective with the one member. But it's important to make sure that the individuals and the client know that it's the entity that's our client, not the individual members, and because you're not all necessarily going to have the same interests. So we make clear that they know we represent the entity.
Todd, Max talks about representing the entity. Are there any safeguards that you guys put in place for what you might do for the individuals or for the other partners? Are you going to have any conversations with those other partners? And does that happen in writing? Does that happen over the phone? How do those conversations go?
Yeah, so we will have those conversations if they're in the situation as we have here, where there are multiple members of the entity and they're coming together to form it. We'll be precise in our engagement letter to start with, so it's very clear in the written engagement that we are representing the entity, and we make clear that we're not representing anybody else, we're not representing any of the individuals, and we will also typically have conversations with the individuals and letting them know that there are possibilities that you're going to have divergent interests in this, and encourage people, if they want, to go get separate counsel. Maybe when we're negotiating an operating agreement or a shareholders agreement, those sorts of things in particular in that entity, to encourage them to seek counsel of their own, to make sure that they're identifying those issues that are going to be important with them. And we'll have we'll have discussions up front if you have multiple parties, explaining to them, okay, here are the types of things you need to consider in this, and in the shareholders agreement or in an operating agreement. But we also want to make very clear that we are representing the entity, and everybody has the option, and in fact we encourage that you do seek counsel of your own to consider your personal issues.
So you talked about a written engagement letter. Max, the model rules don't really talk a lot about engagement letters, but presumably everybody's getting in the habit, if not required, to send them. Tell me a little bit about what your firm requires in terms of engagement letters and the benefit of sending an engagement letter.
We are moving more and more toward a requirement that every new client has an engagement letter. There's a lot of independent judgment that goes into that, including, if if Jackie came to me because she wasn't confident in your ability to represent her, you know, and she was a new client, I know Jackie, you know, so I may not do a formal engagement letter. But we're moving more and more toward that, and it's important for a number of reasons, both for the protection of the lawyer, the law firm, and the client, to lay out precisely who the client is, what the scope of engagement is, fees, put in a recognition by the client that, hey, we have other clients, and we're going to still represent them in other deals that aren't, you know, adverse to yours, and you waive any conflicts that might come up in that regard. And, you know, and here's how we bill, and here's whether we require a retainer. But it's important to get those, and, you know, we'll do some of them by email. Most of them are, you know, formal letters. It's becoming more and more important to do that, and we're implementing them more and more frequently.
Todd, do you require your engagement letter to be signed at Hush?
Yeah, we do. But we've talked about that. Some firms don't do that. We do require that the engagement letters be signed. And in fact, I mean, Max was talking, you know, saying that sometimes it's optional. It really isn't optional for us. We have to have an engagement letter signed by a client on any new engagement. And in fact, if we don't, then there comes a point in the process where they stop allowing us to enter time for that particular client if we don't have the return engagement letter. So it is something that, you know, and I think a lot of that is driven by, I mean, it's obviously extremely important to have a clarity around all of those things with the client on the front end that Max just talked about. But I think it's also, you know, more and more driven by our insurance carriers as well and what their requirements are. And in our particular case, that's just part of the, you know, part of the process that the firm has negotiated to make sure that those you know, professional liability rates stay as low as you possibly can make them. So.
In terms of best practices, and we talked a little bit about this on this subject, and where best practices may differ and insurance companies may differ, we don't require our engagement letters to be signed at our firm. And I don't know if there's a right way or a wrong way. I think we've come to the conclusion that if you can get a signed engagement letter, that's obviously the best practice. The problem for that we were seeing was people would send out an engagement letter with a spot to get signed and then follow up not being as good as it could be all the time, hypothetically. Those weren't always coming back signed. And so it's better to send an engagement letter that you can document receipt of than to have sent an engagement letter, have a signature blank on it, and never get back your signed engagement letter. So I think there's room to do it both ways, but the caution I would give, and this goes for the brokers too, when you're obviously getting listing agreements which take care of many of those issues, but for the lawyers, if you're sending an engagement letter and you're requiring a signature, have some sort of an intake procedure back to make sure that you're getting them back signed, because if you don't, you can end up hurting yourself as well as much as helping yourself. The other engagement letter topic that I wanted to touch on was defining the scope of the engagement letter. Todd, talk a little bit about Awesome Acres. What would you put down for the scope of your engagement, and what, you know, based on the conversations, and what would you want to find out from your client? What are some questions you'd ask Johnny Awesome, and how would you define your scope in that engagement letter?
Yeah. So I think on the front end, it would be trying to get an understanding clearly of what is our role as a firm in the process. So if he says, "Oh, I want you just to handle everything. I want you to handle everything on the transaction," you know, we're going to try to define a little bit of what everything means. And so does that mean that is there going to be financing on the project? Are you wanting us to handle the financing component of it? Are you going to have to go raise capital potentially to do this? Are your three partners that are coming in going to have all the capital, or are you going to have to go out and raise additional capital for the deal? You know, and if so, are you asking us to help in that process and to deal with any securities compliance issues that might exist? And so just try to hash all that out on the front end, and then be very clear in the engagement letter in terms of the scope of what it is that we are doing. You know, if you know, I think it's easy. It's the easiest tendency, I mean, is general business matters. You know, we're going to represent you for general business matters, or we're going to represent you for your real estate matters. And that's the easy way to do it, but it doesn't really define the scope. And so if there are things that come up later, there's two issues in that. One is you can have an issue to come up, well, I didn't know you were doing that. And so you could just have issues around that with the client. But the second thing is you're never really sure where the engagement starts and where the engagement stops. So for future conflict reasons and those sorts of things, you don't have anything that really defines for you what it was you really undertook.
Yeah, some caution here. If you define the scope of your engagement as our firm has been hired to represent Johnny Awesome or Awesome LLC with respect to the purchase of Awesome Acres, that opens up, you may think, okay, I've done my job, I've sent my engagement letter, but you really want to know what all you're being asked to do. If it's only to review the contract, in this case, we gave you it's already been signed, but let's say that the contract hasn't been signed. If it's only to review the contract, you want to limit the scope as much as you can for we're only representing Awesome LLC with respect to the review of a contract and you may even want to specify whether you're drafting, whether you're reviewing, but try and talk about what you're doing, because the second you just say on the purchase, you're presumed really to be doing everything in the deal. And later on, you can run into a situation where they say, geez, our loan documents were a mess, and, well, gee, nobody ever sent me the loan documents. But there's going to be a jury out there that could presume that you were supposed to advise them about their loan and the terms of their loan, and you should have asked them about that. So be very cautious. One trap in engagement letters, now we're all, the world's really changed. I think most of us in the room hopefully are sending engagement letters, but they can come back to bite you if you're just sending out an engagement letter as a matter of routine. Don't get in that habit. Really put thought into what it says. I realize that should go without saying, but it doesn't always in the hurry of bringing in a new matter or opening a new matter. So
just one other thing on that is we're starting to do more and more, and I'm sure a lot of you are too, starting to do more and more things on engagements on a alternative fee basis, so not by the hour. So it might be a fixed fee for the transaction, or some other structure, and then it becomes, again, really, really important in the engagement letter to define clearly what that is. So if you're saying, I'm going to do this transaction for X, it's what does that include? Because because you can have all kinds of other issues that spring up in the middle of it that can, there just be there isn't a meeting of the minds, I guess, with the client on that, and I think the front end of that, that's the purpose. There's the purpose of that engagement letter. You want to have a very clear understanding, so there's no surprises on either side as the transaction progresses, and that's always the best way from a client relationship. If you both understand clearly on the front end, that relationship is going to go a whole lot better.
In the same vein, if there's times where we're serving as local counsel for a client that might not, we may have no history with. They're out of state. They have general counsel or outside lawyers and other professionals. That's another, really critical time in your engagement letter to define, we are only serving in this role for this purpose, and you will rely on your general counsel or this firm for everything else. So that you can avoid the surprises, because those usually are tougher to deal with on the back end.
And you can obviously use your email as you're going into a transaction to document with a client what you are and aren't doing as well, and use your email as a supplement to the engagement letter. Clients generally don't love getting their initial engagement letter, let alone subsequent letters after that. But if you need to say, we're not doing this, or something comes up in the course of an engagement that you need to clarify, by all means do it and follow up with an email to the client telling them what you're not doing. A lot of times you can exclude things from the scope of representation if you're clear. And I'm not shy, frankly, about telling a client this is a CYA email. I don't think, if you're, I'm pointing to Lisa, who's at Union Pacific, if you get something like that, I don't know, yeah, you know the drill. And so you're trying to create a record. And so I think clients appreciate some communication along the way, hopefully. In our scenario, so we've talked a little bit about the phone call. So now you've sent your engagement letter, you've cleared your conflict, you sent a conflict memo internally, you're good to go, except for one critical factor now comes up, which is that the seller, it turns out, is ABC Corporation. An ABC Corporation is a client of your firm. what considerations, Max, are you going to look at? Tell me how those discussions are going to happen and what your problem is and how you're going to work your way around that problem.
Well, the problem is obvious to the lawyers in the room. We can't have dual agency. We can't represent both sides of a transaction with competing interests, which you generally have in a purchase sale example. So the first thing we do once we become aware of the conflict is we let the proposed new client know, oh, hey, we represent this other party. So we cannot represent you unless, one, we aren't representing the other party in this deal. And that happens a lot where we might have clients that we do some work for and they do have somebody else do the real estate work. But then we also have to get waivers from both parties. And it's usually not a problem because we run into it a lot, certainly in, big small town Omaha, where everybody knows everybody and it seems like everybody represents everybody. But if it looks like there's a possibility of, even if both sides agree, if it looks like there's a possibility that things might get sideways because, you know the people or you know the deal, then we'll just bow out altogether and, suggest that they find alternative counsel.
The model rules state that a waiver of a conflict of interest must be in writing to be effective. Todd, do you take that to mean a letter? Do you take that to mean an email? What's your standard practice?
Yeah, we'll rely on an email a lot of times. As long as we get an email from somebody with authority, from the client, we will accept email waivers. Let's do.
Yeah, and we're in the same boat. That being said, we're getting more strict about trying to get a letter signed by both parties, clearly spelling out what the transaction is, who we represent, and that we may represent both parties on future unrelated matters. Sometimes it's nice to get a statement like that just to clarify for the future. But that being said, and depending on the transaction, an email to us has qualified as being in writing as well.
And that is something just on our regular intake process we were talking about before in our engagement letter process. We do, our standard engagement letter does have an unrelated matter conflict waiver in it. Sometimes that's something that going back, you kind of have discussions with a client, depending on the nature of your representation of the client. But if it's a client that you're just doing one small segment of their work and they're using lots of people for other things, we build that right into the initial engagement letter, so there is already a waiver there. You still have to use your judgment as to whether you can rely on that or you can't rely on that, and in many cases we still err on the side of calling the client. The other client that we have the unrelated matter waiver for, and still have a conversation with him about it.
Yeah, Max talked about the magic words dual agency, which for the brokers, you're all familiar with dual agency, and I will caution you as well for the benefit of some broker education. It always, always, always makes me uncomfortable as a lawyer. They're taping this. You want to go on the record shaking your head now? Yeah, for instance, on purchase agreements, again, and some of you in the room know this, but one of my frustrations is you represent the buyer, there's totally competing interest to representing the seller, and to say, well, this is our standard form, you're going to get tagged sooner or later if you go with that approach, because a buyer form of a purchase agreement or a buyer's preferred form of a purchase agreement and a seller's preferred form of a purchase agreement should look very different and should contain very different provisions. And to get to the same place is going to be difficult. That being said, let's say that Awesome Acres, pretty easy deal. ABC company wants to sell it for, let's say, flat $500,000. There's no building. ABC, the president of ABC's buddies with Johnny Awesome. Everything's going to go smoothly. How many in this room have been asked, can you just represent all of us? Just one person. That has to have come up more than once. Okay, we're still going to, yeah, people are shaking their heads. That's not uncommon to be asked to do that. Todd, are you ever comfortable being the lawyer for the deal, so to speak? And what are you going to make sure you do, I guess, if you do that? And I'm not trying to lead you, because sometimes the answer may be no, but tell me a little bit about that.
Yeah, that's tough. I mean, it's. I'm not going to say I've never ever done that. You know, where the circumstances where you have a relationship with all the people, and you know, you feel comfortable that you can do that. You still have to have, as we talked about before, just all the waivers and clarity around, you know, everybody acknowledging that there could be issues that arise in that dual representation, and that if they do arise, then basically you have to bow out completely, and your engagement would need to clearly specify that you know, if at any point either party feels like there's a reason why they're not aligned anymore, that you're really going to have to step out of the deal completely. And you have to be prepared to be willing to do that if you're going to take on that joint representation.
Yeah, and that comes up a lot when you talk about not being aligned anymore. Even within who your client is, you've always got to be looking out for that within your LLCs or your entity formation, that there's going to be times when everybody's on the same page. But talk, Max, a little bit about within the LLC, you know, sometimes where you may see folks getting sideways, and where that happens within an LLC on a real estate transaction.
Well, the easiest example is where you have multiple members, but not all of them, well, they're not equal. Okay, so some of them might be very passive and maybe putting in a bunch of money and looking for a different sort of return. You might have a couple of bigger hitters who want all the power and the control, but they need the minority owners in order to pull off the deal. You know, right from the get-go, they don't have the same interests, because the power people want to be able to call all the shots, and you know, the little people want to be protected. So that's where it's extremely critical to let them know, look, we're going to paper the deal. You know, we'll draft the operating agreement, but you all really do need to get independent counsel. Maybe they will, maybe they won't, but it's good for us to put that in writing. It becomes trickier where you might, you know, let's say some of the members, you know, whether it's the power guys or the little guys, might already be your clients, and everybody else is new to your firm. You know, so you have this relationship already. They're expecting, and I've had people say this, you know, here's our multi-member LLC, and you know us, you've done work for us, these are new guys, just look out for us. I'm like, no. You know, we can't do that, you know.
Because they'll look out for you if everything goes wrong, Max.
Yeah. So, you know, that's where it's important. You can still, you know, be the lawyer for the entity, but they have to acknowledge and agree that, you know, if they want separate counsel, they go get it. And then really, you kind of take pains to, if you're going to proceed, to make sure that everybody clearly understands, here's what this operating agreement says, here's what the buy-sell, here's what the capital call requirements are, so that everybody, you know, has an idea and full knowledge of what's in there.
Yeah, Max, the two magic words there, or I guess the two magic phrases that Max just talked about, were capital calls and buy-sell, that you'll find out quickly that people aren't on the same page. And some of this, hopefully most of this, is preaching to the choir, but again, we're getting our hours of ethics for it, so that's good. But, you know, capital calls and buy-sells, make sure your forms of LLC operating agreements really do clearly spell out buy-sell provisions, because they become much harder, if not impossible, to deal with later. One other just kind of anecdotal story, if you're in a firm as opposed to a solo practice, to the extent you're a lawyer for the deal, consider having two different lawyers within the firm work on that transaction and clearly spell out what's happening in the lawyer for the deal letter, or your engagement letter, and your whatever conflict waiver letter you set up with that. It may help. But the flip side to that is you want to still be crystal clear that the firm, that even though you're different lawyers, that you're considered to be have the same issues. So just again, it comes back to really spelling out everything clearly in writing to the extent that you can. All right, so back to Awesome Acres now. Everything's going great. We'll get back to some slides here because I want to have this one up when we talk about it. Max, hopefully you studied this part because I'm coming to you here.
We'll find out.
Maybe. There we go. So Johnny Awesome says, you know what, Max, this is a great opportunity. I think Awesome Acres is going to be huge, and your hourly fee has gotten way too high for us. How about you just take a share, take an operating share in this deal and do that in lieu of fees? Tell us a little bit about those situations, and again, what your considerations are to take equity in a deal.
Is it for me personally or my firm? Well,
Both.
let's say they offer it to me personally.
For your firm. Well, that goes without saying that you better be real careful if you're in a firm to know that this is the firm's decision and not your decision individually.
That's my point.
Yeah.
That's my point. That is something that happens. We have done it on less than a handful of occasions where we have, in lieu of fees, taken an equity position. Again, you can do that. You have to have full disclosure. It's risky because there is any number of circumstances that could arise where our economic interest in the venture is no longer aligned with whoever might be running it or the client's interest. So it is something that can be done with full disclosure. You have to explain the risks to the client, and they have to waive off any conflicts. But if something arises, there's a good chance that A, we're out of the representation, and B, we're probably going to get sued.
For the brokers in the room too, most of the brokers are going to want equity in the deals that they're in many of their deals, and that's not uncommon for brokers to want to take a commission on deals that they also have some equity in. And when I talked about dual agency, that gives me less heartburn for the brokers in that scenario, as long as, again, you're documenting everything through your listing agreement. That's going to be a little bit more expected in those deals, and frankly, how you make your money. The problem becomes, like Max touched upon, if the deal blows up. Todd, what are some examples of where later on in the deal you've seen that maybe get uncomfortable, where you have to make some uncomfortable decisions or determinations as a lawyer when you're in the deal?
Or you say based on when you've taken a stake in it, you mean, or just
Yeah, where you've got equity in the deal. Where do they blow up, basically?
Regardless of whether it's
yeah,
in lieu of fees or just
having
cash.
Correct. Yeah.
So they gave
Well, I mean, it's the same. It's really the same issues that come up with any type of partnership, and the same issues that come up with shareholders in a deal or members in a limited liability company. I mean, it's usually when things are going bad. It can be issues around who's signing guarantees on the deal. It can be issues where there's need for capital calls, and disagreements as to whether or not and how that should be done. And so it's really when you do that, you really, I mean, what you're doing, you're obviously becoming a member of the entity or a shareholder in the entity, and so you're going to have all the same issues that any shareholder has in the entity. And in most cases, not always, but if you're doing it in a limited context like that, you're probably coming in a minority position, and so you really are probably not in a position to be able to have a lot of say in those things. And so you can very quickly get into a conflict issue where you're going to have, you said, bow out of the representation, and plus have issues just to deal with because you're a minority
Right.
in a partnership.
That
Kind of further complicating it might be if you're wearing several different hats. If you're maybe a manager in the LLC and you're legal counsel for the LLC and you're an owner of the LLC, it can, those lines can become blurred, and it would be easy to kind of lose track of which hat am I wearing when, which, if everything goes right, is never a big deal. But as we all know, when things go south, that's when fingers get pointed and you might have issues.
Yeah, and once you're the lawyer for a client on a transaction, I think that goes back to what we were talking about with engagement letters, where once you're the lawyer on the transaction, you're presumed to always be the lawyer on the transaction, particularly if you have said we represent Awesome Acres LLC with respect to the purchase of. That's a lot of times going to be read to be ongoing management unless you cut that off, and so you've got to really be super careful in writing if you're going to take an equity position in a transaction. Probably a good spot just to stop. Are there any questions, anything anybody wants to discuss before we keep going? Nobody? Oh, this is exciting. Okay, good, there's a question.
Oh, geez, it's a lawyer.
In the case where the law firm takes an ownership interest in the client, I assume then when your malpractice insurance application comes around next year, you're revealing that ownership interest. Have you had any experience with how malpractice insurers look at those kinds of relationships? Do they exclude them from coverage? Do they rate them differently?
I do know that they have to be disclosed. I don't know what happens with the rest of it.
Yeah, to the best of how it works within our firm is, yes, we definitely disclose it, as we have to disclose whether we're a shareholder or officer in, a board member in any, whether it's for-profit or nonprofit. We make those disclosures for the benefit of our insurer. To my knowledge, our insurer does not exclude those transactions from our coverage. But again, I think they'd be very critical upon when are you acting as a lawyer and when are you acting on behalf of the entity when they're making coverage determinations. So just because they don't specifically exclude it at the time of intake doesn't mean that they won't try to exclude it at the time that something blows up, particularly on whether you're acting on behalf of the firm or on behalf of the entity. And that's frankly why I don't like those types of deals personally, because they just give me too much heartburn. For me personally, it's just easier to practice law and not make some of the money I can make, I guess, so.
I was going to say, there's no question that affect rates on the insurance. So, I mean, particularly if as a firm you've kind of made the decision we're going to do this on any kind of regular basis, it will absolutely affect your professional liability rates.
Yeah, that's a great point. The rates is probably the biggest effect for sure. Other questions? All right, well, we talked about our story, and everybody was we were quick to send out a conflict memo to have the conversation. Let's say that we were going a little slower at intake. Max, if you had time to ask Johnny Awesome about all the potential conflicts and issues, what kind of other questions should you be asking up front? And if you don't ask them, what other parties come into play? It seems, what are some of the broader questions you'd like to ask, if you can, when you take in a new matter?
Well, depending on, let's say they're buying ground for development. So you want to know, what other professionals do you have involved? Who's going to be assisting you with various, planning and zoning, financing, surveys, the ancillary professionals that do what has to be done for there to be a project. So in addition to just finding out who the client is and the other members, you want to know who are the other professionals, lenders, because we do pretty much, especially in the commercial real estate world, everybody knows everybody, and we've all worked for lots of the same clients in one shape or form, or persons that might be constituents of those clients. So it's critical to know everybody that's involved so that you can identify where do you have a conflict. Take lenders, for example. If you're a big national bank in Omaha, you might use lots of different law firms for different things. Same work, different work. Many of them will have kind of standard engagement letters where they say, okay, lawyer A, you're doing loan work for us. If somebody else in your firm is representing a borrower of ours, we'll pre-approve that, or here's somebody you call to get it pre-approved, but you can't work on it. They'll sometimes say, you lawyer A, if you're doing our work, you can never represent a borrower of ours. So it's important to know who all those players are, just so that you can make sure that you cover and clear any conflicts.
Todd, so Max is talking about banks. At intake, Johnny Awesome told you they've got all the cash they're ever going to need. They don't want your equity or need your equity. Everything's fine. And then, lo and behold, about 3 months later, you get a call from the president of ABC Bank, who says that, Todd, I always like using you. Tell me We've got a great loan that we're going to make some serious cash on. It's this new developer, Awesome Acres LLC. Presumably, you're going to say timeout right there. Walk me through that scenario.
Yeah, those are the ones that you try to avoid on the front end, but you can't always, for sure. And so that at that point, immediately my response would be, oh, well, we're actually representing Johnny in that deal, and we've been in it from the beginning, and so we're not going to be able to represent you, a lender, in that situation. And depending on the circumstance with that lender and what our relationship is with the firm, it could end up in a situation where we can't represent anybody. So what I probably most often in that situation say is, we've been in this from the beginning. I know we do a lot of work for your bank too. Are you comfortable with us handling this? And if so, at that point, we'd have to again get a written conflict waiver from everybody in the deal, acknowledging that we have this conflict and that they're okay with it. But there's been situations that come up like that where you have to bow out of the deal, and sometimes it's not, you don't want to be in that situation, but sometimes that can happen. And when you're in a firm, especially in a firm if there's a number of lawyers in the firm, those relationships, there's just business conflict issues too, where the firm may do millions of dollars of work for that lender, and all of a sudden we're telling him we can't represent you, we want to be on the other side of you, and the attorneys who do all the work for the lender are like, wait a minute, we don't want that to happen. And so there can be some issues that just have to be worked through all the way around in those situations. And so that's why it's try to get as much as you can up front.
Yeah, brokers, banks, title companies, surveyors, engineers, contractors, potential tenants. Those are all a laundry list of potential conflicts that can arise that you're not necessarily thinking about up front. But Awesome Acres is going to be a commercial strip mall. You might ask up front, do you have tenants lined up? Who are they going to be? And if they don't have tenants, at least what types of tenants do you see being coming along here? If you know that it's going to be that they're going for big name national dry cleaners and you represent a big name national dry cleaner, you might want to at least just have that discussion up front or start thinking through those conflict scenarios sooner rather than later to make your life a little bit easier. All right, so let's talk about the good and the bad out of the transaction. Let's talk about the bad first. Max, I'm going to ask you, but that's not any reflection on you. This is a pure hypothetical. This would never happen to you. This is a part where I do want to make sure I'm reading the rule as we go. So bear with me. Too much paper. Let's say that Johnny Awesome got his deal done, shows up and finds out later on that there was a holdback provision in the contract where they were going to pay an additional $100,000 depending on any number of factors that they weren't aware were in the contract that you drafted. You drafted the contract here. Again, hypothetical. This is Jenny Lawyer, not you, Max, because you would never let that happen. But says, darn it, now we're getting sued by the other party. Do you have a really good litigator over there who can make sure we win this lawsuit? Are you going to take that lawsuit and tell me what factors play into that?
I think the first question is, am I going to take that call? I'm kidding. Yeah, if you realize you've made a mistake, or potentially, we don't like to say the M word, but if there are grounds for an allegation of malpractice, then the threshold question isn't, do we have a litigator that can do that? But at least internally at first, it has to be, oh, did I screw up? And if so, is it actionable? And even if it isn't actionable, is this tenant or this client likely to assert a claim against us? If that's the case, we have to, well, the right thing to do is to tell the client, if it looks like there's no other way out, you tell them, I may have made a mistake here, and you should probably get other counsel.
Yeah.
As painful as that, hypothetically would be, That's what you have to do.
And that's where the rule is worth reading here, which the model rule 1.7 says that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. So again, that's a judgment scenario, but some magic words there are, first of all, that a lawyer shall not represent a client, not may not, but shall not. And again, personal interest of the lawyer, well, if you're going to get sued for money, that is a personal interest of the lawyer, whether it's your firm or whether it's you. So you may need to just be ready to identify prior work conflicts and know that you have to get out sometimes. You can't take every representation, else then you're in a situation where you're possibly not only committed the M word on the front end, but on possibly the ensuing litigation by the mere act of taking the ensuing litigation. So just know when those situations arise. True story, yesterday I got a call from a client saying, do you remember that deal we did a couple years ago? And
I hate those guys.
right, and I said, of course I do. And they said, well, this is really delicate, and I'm not quite sure how to put this, and I just, and it was like, we really like that form that you used on that. Can we have that form in a template? I'm like, well, yes, you own it, and that's great. So, but
That brings up a good point, because clients will do that, and this day and age, the older I get, the longer I'm in practice, the more defensively I practice. So I will provide them that form with a bunch of disclaimers that I haven't looked at your deal, it's not been drafted for any specific deal, I recommend you have a lawyer look at it when you modify it. But, again, to avoid the situation 2 more years from now where he calls up and says, you know that form you gave me? That deal didn't turn out too well, so I'm going to sue you now. So, again, kind of little CYA, little education.
yeah, you can give somebody the best form in the world, and if they're not using it properly, identifying parties properly, it can be meaningless. And so I agree with that. Anytime I'm providing a form, I try and attach a caveat in an email in writing that this is merely a form. I suggest you hire a lawyer every time you use this form. Most clients aren't going to be thrilled or do that, but at least you've tried to cover yourself. But again, most of the forms, an ounce of prevention is still worth a pound of cure, even depending on how good the form is. All right, well, good news for you, Todd, because you get the better scenario of the two, which is that Johnny Awesome loved your work. He's now living in the Caribbean, spending his money and letting Awesome Acres just pay him an incredible rate of return. And he says, Todd, thank you so much. I'm going to fly you down to the Caribbean for a weekend for a little thank you party. You hopping on the plane?
Yeah, I think there's it depends on the circumstances, right? Maybe.
We already have a tan.
Oh, okay. Well,
So
that makes
so
it
you don't have to risk
yeah.
burning. So obviously you go.
Well, in that situation, there's a threshold, and sometimes it's not clear. Sometimes it is. Sometimes a firm will have a policy that says, if you're receiving anything, beyond. So this is something that's already passed, right? The deal is done. It's not. I'm not getting paid in that circumstance for something that. It's not because because he referred work to me or something like that. In this instance, it's work for a client that was done. I think Johnny's paid his bill in full. That's right. It's completely paid. And so, there's a line there. And I think if it was something like that, I'm going to fly you down to my, on my private jet to my, home in the Caribbean for 2 weeks. In that instance, first thing I would do is make sure that I disclose, if I was even thinking about that, disclose that to my firm that, hey, that we did this deal, they've made this offer. Is there any issue with that? Because we have situations, there'll be, so that's one extreme. You may have a client that says, you did an acquisition, deal went really well, closed, and they want to bring the people from the deal team to New York for a closing dinner. You know, and they're flying in all the people that were involved in the deal, and you're going to go in and you're going to the closing dinner. You know, that instance, I wouldn't have a problem with that. I think that's just kind of ancillary to it. But we get into a whole different issue, which I'm sure is where you're going next. But if you're getting those, you know, if that's coming in connection with a referral relationship, or we're paying somebody, you know, we're flying him to, you know, our place in the Caribbean because he referred the work to us. I mean,
Yeah.
that's a different issue.
And to the model rule, just so we're covering it, the model rule is pretty clear on those types of gift, that a lawyer may accept a gift that meets general standards of fairness. So again, it's a judgment call. Use your judgment. If the deal was, you know, a multi-million-dollar transaction, a closing dinner in the Caribbean in New York may not be without outside of that standard. If you're closing a $500 deal and then they offer to do that and say, hey, send me your next piece of work this way, then you're getting into kickbacks and referral fees, and that's where you really need to be extra careful. We're running out of time, but that last question. So Johnny sends you that work, takes you to the Caribbean, sends you a client his way, and says, hey, can you maybe send me a little finder's fee for that deal I sent? You're going to make $100,000 in legal fees, Todd. How about $1,000 of that back? Tell me whether you're okay with that.
No.
Yeah, me neither.
Yeah, I mean, that clearly we cannot do.
Yeah.
So we never, as an attorney, we pay somebody a referral fee.
Yeah, that same comment to that model rule, lawyers are not permitted to pay others for channeling professional work. So some of these rules seem self-evident, some...
One, maybe it's a little bit of an exception to that, is you can join like tag law or you know, other professional organizations like communities of lawyers or law
Right.
firms where you might internally refer work, but it's not that scenario.
Yeah, and you can have cross-referral relationships with say, accountants or, you know, real estate brokers. Where you know, there is a, you know, in the model rule specified it doesn't prevent, you know, that. But if you're paying somebody for the work, you absolutely can't do that.
Right. That's about all the time we have left. Hopefully you guys found this of value, and like I said, you still get your ethics credits either way. Any questions before people are already getting up and ready to run? My God. All right, well, thank you all very much. Appreciate your time.
You know, more stuck around than I thought might.
Nobody's sleeping. I don't know. It seemed like our practice went better than the real thing. We practiced too soon.
Trenton was the only one that was nodding off a little bit.
Well,
But even with him, it's hard
he
to
can't
tell.
stay awake more than half an hour. Thank you. Nicely done. Rich, how are you?
Did you plant him?
No.
Oh, yeah.
Right. Follow any of this crap. Yeah, we all hit a panic today when we started getting asked, you know, are brokers getting credits for this too? And we're like, shit, this sounds like it could be, you know, so if nothing else, though, you get a eat. If nothing else,
He's not going to call me about anything, is he?
you know what? However I can get it, I'll take it, Rich. I'm okay with that. Plus, if nothing else, it gives you a mindset in the way we all think, which is we're all scared as shit of everything we do. So
Do you think there's any basis?
it's a scare. Well, no, I'm kidding.
Hindsight's always 20/20.
Wait, am I still on the mic? You cannot.
See? It's all because they abandoned some cattle to us.
Thanks. Appreciate it. I somehow, like I said, no, it's like a little more energy when it's wasn't a room full of lawyers, you know. But, I know. Doesn't that sound appropriate?
Well, the UCC, it's the
it's good to think about these things.
As long as it's abandoned animals or sold commercially raised, then it's that less expensive.
Yeah.
Now you can have an agreed
How are you?
I wanted to
value that
introduce
gets
myself. Jackie
assigned.
Pepper.
Yeah.
We've done the deal together.
Yep.
Never met in person.
Parties
Yeah,
to agree
nice to meet you.
parties to agree.
Jackie's the real brains behind the operation.
Yeah, I
tell.
used to office next to John. So now he moved to a different floor, and I don't get to see him as often. I've got to come to this.
Don't hear any
Yeah.
other language anymore.
I know. Actually, now I'm the
We
colorful
abandon them,
language
we
person
can
on the floor.
take
I think
praise
Tony's
value
next to you.
against So,
Good for him.
but it's interesting because
That's good
now,
for him.
all of this,
How many floors do you guys have in the building now?
they're suing him for $5 million. Plus,
And-
they're asking him to disgorge
Thanks,
legal fees
yeah.
of $500,000.
For now.
He ran up $500,000
How long does it remain there?
Are you guys? Are you working with Adam? Some Kirschenbaum?
Yeah.
He fought everything.
Yeah, I just like to
Having
flip
a
shit
legal
though for
trial on our claims.
running over to Miller, which I
Boy, that was
It
a
was just.
that was a crazy
But
situation, wasn't
anyway,
it?
I just want to,
Should have been summary judgment place, probably.
well, but it was interesting because,
Yeah,
it's,
yeah, that was
it's Jim Sharon's office.
that was really unfortunate. Yeah.
Representing
You know what though? I told Adam too. It's like
We're all glad
it
we're
was
not
better that it happened that quickly. Than you know, if it's 3 years down the road and that happens, it makes it a lot harder. You know,
Oh, yeah. Wow.
I agree.
Good job. I just wanted to say hi. It's been a long time.
It has been. What have you been doing? Well, you know what?
Try to keep this guy
I
out of
mentioned
trouble.
to Todd the other day when we were riding down the elevator from practicing at your place.
I've been for sure.
I never run into. I very rarely run into people from the other, well, almost any law firm it seems, but bigger firms here in Omaha.
I got into environmental.
You know,
it's true. It's strange, but it's true.
as small of a town as this is, you know, you would think on any sort of commercial deal happening here,
Attorneys that
that,
go in and do.
you know, one of 5 or 6, you know, firms would be involved, but a lot of times it isn't. You guys don't run into us, we don't run into you. Yeah, it's kind of funny. How's things going?
And,
Yeah?
you know, I can
How's the children?
Oh my gosh, my oldest one is doing first communion in a couple
Oh,
of weeks.
second grade, right?
Second grade, and my youngest will be starting kindergarten.
Wow.
So,
Kindergarten already.
Kindergarten already.
Wow.
Yeah. So
My oldest gets married in 6 weeks.
It seems like it was just then. Doesn't I mean seriously?
And my
You always hear
youngest,
people say that. You know,
Yeah.
it's like wow, it really does.
and my youngest is a junior in high school, so.
yeah, so we have our first spring, 5-year-old 3-on-3 soccer game today.
Oh. If you suffer through that and just be happy for the kid playing,
I know.
the bubble, you know, the bunch ball is,
Yeah.
Yeah.
but
I remember our daughter. Her soccer experience was she would go on the field
right.
and she'd just stand there. She wouldn't run. She wouldn't do anything. It's like
Maggie, my oldest, always danced. But when she was playing soccer, she always wanted to play goalie so that she could just do cartwheels and,
Yeah.
you know.
Yeah, so my 5-year-old who last fall during his soccer league came up with the new defensive move where, you've got all these, 6 kids, 3-on-3, and they can't keep track of the ball, and so he happened to fall down and fell over the ball and was kind of like over the ball like this, and all the other kids,
my precious.
he's in the fetal position, hiding the ball. It's mine, it's ours. Trying to figure out. Then he stands up and is like, surprise, and kicks a goal.
That's awesome.
They'll learn later they're not supposed to use their hands and lay on the ball.
Figure it out,
That's awesome. It's fun. It's fun. Now, you got 2? How many kids? You have 3? What are your ages again?
21,
Thank you.
18, and
Okay.
almost 13. He'll be 13 in a
Thank
week.
you for the last half hour. I'm gonna run.
Yeah.
Thank you, John.
I'm not in charge next year.
No. Rochelle is.